Hello, I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth metroplex. And today is part 2 of the series on choosing a fiduciary. Previously, we discussed some general attributes to consider when choosing a fiduciary. In addition to these general attributes, there are some additional criteria one should consider when making the selection for each type of fiduciary. You should include the following questions in your decision-making process to guide you to make the right selection. For an agent under a healthcare power of attorney, ask, does this person have the ability to make tough, emotionally charged decisions quickly? Will they be able to effectively advocate for your wishes to medical personnel and to family members? Do you both hold the same values? For example, it would probably be unwise to pick someone who doesn't believe in blood transfusions if you do. Are they available to quickly arrive at a medical facility in the event of an emergency? For an agent under a financial power of attorney, are they responsible and trustworthy? Are they financially astute enough to make complex financial decisions, such as assessing investments and filing taxes? Now, for this one, I cannot stress enough how important the selection of this fiduciary is to your estate. As discussed in a previous video about powers of attorney, this document is incredibly powerful. A rogue fiduciary can financially devastate your estate. For a guardian who will handle money or property for a minor or incapacitated adult, does the person know your values and principles? Do they have the life experience or anticipated lifespan to care for the dependents for whom you are planning? What is the current geographic location of the potential guardian? And what could be the impact of a move on your dependent or on the guardian? Are they financially able to care for the minor or incapacitated adult without undue stress? Are they willing to take on the responsibility for the dependent's care? For a trustee of a trust or an executor of a will, is the person organized? Are they accountable? Can they withstand pressures from beneficiaries or third parties over the course of the trust or estate administration? Is the person in good financial standing? For instance, they should have a good credit history, no liens against them, and have never declared bankruptcy. Would they likely be available and capable of serving as executor when the time comes, even if it's years down the road? If you cannot identify an individual in your circle of family and friends to fulfill any of these roles, or if circumstances dictate that the use of a third party would be the most advantageous, then an institution like a bank or trust company or an individual professional like an attorney can be considered for the fiduciary tasks. While not typically recommended, in some specific instances, you may wish to consider appointing co-fiduciaries. Trust protectors may also be used as part of a multi-layered system of checks and balances. In all cases, you should strive to select fiduciaries who can work together to ensure that your legacy is carried out successfully and according to your plan. I'm Antoinette Bone, estate planning, probate, elder law, and guardianship attorney in the Dallas-Fort Worth metroplex. You can call me at 817-462-5454 or email my office at info@abonelaw.com to schedule a time to start your estate planning journey. If you found this content useful and would like to see more like it, please subscribe to my page and don't forget to tell your family and friends. Thank you for watching, and I will see you next time.